this webinar entitled Beyond the Letter of Law, our current international legal framework. Professor of public health at Johns Hopkins Bloomberg School of Public Health, and I direct the Center for Humanitarian Health here. And it's a pleasure to have you. And this is going to be one of our first webinars, one of 4, where we're going to be discussing key issues in the humanitarian space, key challenges, as well as what we may be able to do to try to address them. This is part of a Center for Humanitarian Health Lancet Commission on health, conflict, and forced displacement of 2026. And one of our goals for this webinar and the webinars that will occur in the future is to discuss, as I mentioned, key issues, but also to give you an opportunity to respond. And therefore, at the end of this webinar, I will share a link where we have 4 questions, and we hope that those of you that are interested and passionate about humanitarian law will be able to upload your answers, and then we'll take it into consideration as we move forward on this Lancet Commission. So today we have 3 panelists, as well as the executive editor of the Lancet joining us. So I will do a brief introduction and then hand over to Anna Mateus, and then we'll start the webinar. So I'm going to introduce everyone at once, and that way we can move smoothly forward. So Anna Mateus is the executive editor of the Lancet and the Commission's focal point for the Lancet. She's particularly passionate about health promotion, equity, commercial, and social determinants of health and policy. David Cantor is a professor and founding director of the Refugee Law Initiative at the School of Advanced Studies, University of London. And David's research is a strong legal and policy focus on protection and solutions, including in contexts of conflict, criminal violence, disasters, and climate change. Malavika Rao is a postdoctoral researcher at the Cambridge Centre for Environment, Energy and Natural Resource Governance at the University of Cambridge. And Malavika's areas of research are environmental law, migration law, the right to food, and climate change. And her doctoral work explored the application of the principle of non-refoulement in international law to people fleeing food deprivation. And finally, Hugo for social justice at the University of Oxford and at the Institutes of Ethics, Law, and Armed Conflict. His career is combined academia, policymaker, humanitarian policymaking, humanitarian diplomacy, and frontline operations. So we're thrilled to have such an esteemed panel. Anna, over to you for some brief comments.
Thank you, Paul. So the Lancet aims to use science as a lever for better health, equity, and justice, and also to generate knowledge for better patient and public health outcomes, and also to promote research as a tool for accountability. So our vision is to provide a forum for research practices and policy to demonstrate the power of science to improve lives. So Lancet Commissions represent an important format in this vision. So Lancet Commission is a scientific review, inquiry, and response to an urgent or perhaps neglected and studied health predicament. It involves collaborations and partnerships with a range of experts with different relevant backgrounds to define the scope of the problem, the causes, and potential solutions. And it aims for impact and transformational change, and therefore especially focused on policy recommendations and political action. And this commission is particularly timely and important to us. So last year saw the highest number of state-based conflicts since 1948. And at the end of June this year, over 122 million people worldwide remain forcibly displaced. International law is routinely being broken without any consequences, and the humanitarian system is overwhelmed. So as Paul has put it in a publication at the Lancet, the system is no longer fit for purpose. So at the Lancet, we are hoping for this brilliant group of experts which have joined this commission, which include people from different backgrounds and geographies, and also some commissioners which actually have lived experience. So we are hoping they will reimagine the humanitarian aid system with a focus on health, and to provide bold, optimistic, and inspiring recommendations which challenge the existing systems, and also put affected populations at the center. Over to you, Paul.
Great, thank you, Anna, and thanks to Lancet for this opportunity. So next we're going to go to David Cantor. David, over to you, and thank you for joining.
Well, many thanks, and good morning, good afternoon, wherever you are. If we're talking about beyond the letter of the law, I think it's a good starting point to think about what the law actually says. And in the next 10 minutes or so, I'm going to aim to give you a brief overview of what some of the principal international legal frameworks have to say about this context of health, conflict, and displacement. We're going to start with international law simply because there's a wide range of rules and regulations at all sorts of levels, but at least from the perspective of international law, if you like, sits above them, sits on top of them, and those lower hierarchies of rules should, in principle, comply with these broad overarching frameworks. I'm going to aim to look at three of the main frameworks which touch on these questions of health, conflict, and displacement, and they're human rights law, the laws of war, otherwise known as International Humanitarian Law, or IHL, and International Refugee Law. And what we'll see as we move through them is that all three of these bodies of law integrate the principle of humanity or human dignity, but often they're balancing it against other considerations. And how that plays out determines really what the scope of the frameworks looks like. So if we start with international human rights law, this is a body of rules composed primarily of a set of treaties within the UN and various regional forums, as well as customary international law. And if you like, it provides the ground floor of protections in relation to health and conflict and displacement. It's generally applicable, so it doesn't just apply in contexts of conflict or climate change or cross-border movements. It applies on a general basis and not just to specific contexts. And in essence, what human rights law treaties do is they set out catalogues of rights. And the scope of each of those rights very much depends on the balance between humanitarian interests and other interests that are at play. So, for example, we have some absolute rights. The protection against torture, the right to be free from torture, is one in which the humanitarian imperative is untrammeled. There are no other considerations against which it's balanced. It's simply a prohibition. Torture is forbidden. But many other rights balance the right against some other state interest, whether that's the rights of other people, public morals, state security, or whatever it may be. And thus the contours of right protection will vary from area to area, depending on the relative balance between the right and the interest. Now, if we're thinking about health in this context, there is, of course, a right to health. And I suppose this is made up of various different components. Of course, there's a right to the highest attainable standard of health, which is a socio-economic right and is protected in international treaties in various locations. But sitting around that, there are also a whole set of indirect protections. For example, the right to life protects health, freedom from torture protects health, and so on. So the right to health is reasonably well established in human rights law, and the contours of it are relatively broad, I think it's fair to say. By contrast, if we're looking at the theme of displacement, most human rights treaties don't actually talk about displacement, and they certainly don't prohibit it. But you can infer a prohibition on arbitrary displacement from broader rights, things like freedom of movement and choice of residence. And so, although displacement isn't specifically mentioned in human rights treaty law, we can say that it can be read into that. Having said that, alongside human rights treaty law, there are emerging bodies of law in the field of the protection of internally displaced persons, and some of these treaties, particularly in Africa, do contain specific prohibitions on displacement. The important thing to note around the prohibition on displacement, though, is it's a relative protection. In other words, nobody has an absolute right not to be displaced. A state can allow or order the displacement of people for a range of reasons, so long as that's balanced against the rights in question. There are perhaps two further areas of interest in relation to human rights law. The first of those is, although of course states have an obligation to respect the rights set out in human rights treaties within their own territory, most human rights treaties nowadays recognize that those state obligations also extend where a state is acting outside its own territory, in particular, where some territory outside its own territory is under its effective control. And that could, for example, be in a conflict context in the case of occupations. Equally, it can apply to people who are under the effective control of a state's agents outside its own territory. So the fact that there's an international conflict doesn't necessarily prevent a state's human rights obligations being transferred as it acts outside its own territory. The second point I wanted to make is that it's now generally accepted in the human rights field also that these human rights obligations continue to apply in contexts of armed conflict. The only exceptions are that where that armed conflict constitutes an emergency, then states may have the power to derogate or suspend their obligations in relation to certain rights. But of course, this is subject to various legal checks and balances. Also, in armed conflicts, it may be that we have to read the scope of protection of human rights law in line with international humanitarian law as the body of law more specialized in relation to the subject matter of armed conflict. So going on to think about international humanitarian law, clearly this is a body of law that doesn't apply generally, but applies only in relation to situations of armed conflict. It doesn't tell us anything about the legality of the conflict, whether the conflict is being waged lawfully. All it tells us is about how the conflict can be waged, and it applies a threshold criteria. So there are questions about whether certain situations of violence in contexts like Mexico or Ecuador, El Salvador, and so on, might reach the threshold for IHL applicability. Generally, IHL is seen from the standpoint of the perpetrator, so it doesn't really talk so much about rights. And it's based on a distinction, in essence, between civilians and combatants. And in essence, civilians can never be targeted for attack, unless, of course, they're directly participating in hostilities, whilst combatants can always be targeted for attack. IHL contains really two main sets of rules. One of those sets of rules is how any party to the conflict, that could be a government's military, it could be a non-state armed group, has to deal with people who are vulnerable and in their hands. So, for example, civilians who are in the hands of an enemy party to the conflict, there are a whole set of rules about how they deserve to be treated. The same is true for prisoners of war, the wounded, sick, and shipwrecked, and as classes of combatants. And they include a whole set of guarantees in relation to issues such as humane treatment, detention, and so on. But of course, IHL also contains rules about how war can be waged, in other words, the conduct of hostilities. Now, these include broad prohibitions against, for example, starvation of the civilian population, but they also contain rules about how attacks should be carried out. And there's considerable interest, of course, in the way in which civilian incidental loss can be justified in relation to particular concrete military objectives in an attack. What's commonly called collateral damage. IHL regulates that issue. Now, of course, on the healthcare issue, IHL accords special protection for medical units and also, of course, medical buildings and so on. But it's important to note that this is lost if the medical personnel commit acts harmful to the enemy or the buildings are used for that purpose. On displacement, equally, IHL is one of those fields which does contain specific rules about when displacements can be ordered or not. And usually that is for imperative military objectives or the protection of civilians. Otherwise, displacement for reasons related to the conflict is not allowed to be carried out. So coming on to the last field of law, international refugee law. International refugee law is, by contrast, if you like, the last resort of people who are subjected to extreme forms of suffering. And fleeing your own country to seek asylum elsewhere is really the only means of protection still available. Now, of course, international refugee law balances the humanitarian principle not against military considerations, as is the case in IHL, but broadly against state interests of immigration control and security. And the UN Convention defines refugees as people who are outside their country and in effect unprotected by their own state. And in the case of the UN Convention, What unprotected means is that they're people who are fleeing persecution, in other words, extreme forms of discrimination, against which their state's not willing to protect them or is not able to protect them. And it's important to note that persecution can, of course, take place in any context. That can be during peacetime, during dictatorships, during generalized violence, and of course, during war as well. Of course, breaches of the essential rules of these three bodies of law are often criminalized in national law, but some of these breaches will also be crimes under international law. And there's a specific body of international criminal law which describes war crimes, crimes against humanity, crime of aggression, and so on. So although we often talk in international law circles about the fragmentation of international law into different fields or bodies, there's actually considerable complementarity between the three frameworks. In other words, they give generally good coverage in terms of protection in relation to health, conflict, and displacement. And there are relatively few instances of conflicts of rules. At the same time, I think it's important to emphasize that these are not rules that are ideals for a perfect world. They protect a relatively expansive set of core interests inimical to human dignity, but in some cases, those are balanced up against real-world interests that prevail, for example, in the anarchic context of conflicts. The extent to which this is done varies very much depending on the rule in question and the context in which it's being applied. It also has to be said that they're rules that were mostly created in the aftermath of terrible crises, such as the world wars, by people who understood those events and the balances that might be achieved. Despite this, nowadays it's increasingly common to hear the refrain that these rules or these bodies of law are outdated. But what exactly has changed in the intervening 70 years? And why do those changes matter? Where might we think that the rules are no longer a correct balance between humanity and these other considerations? So with that in mind, I'll move on to Malavika Rao, who I'd like to invite to speak about the implementation of those sets of rules. And I look forward to questions later on.
Thank you, Professor Cantor. Today, I would like to discuss three interconnected themes which are critical to understanding the gaps and challenges in relation to implementation that demand urgent attention. Firstly, I want to outline what the legal procedures and mechanisms are through which international laws are implemented. Secondly, how international law is implemented in relation to health and displacement during conflict and the practical limits in such situations. And finally, what are the incentives and constraints for compliance in conflict situations generally? On the first point of implementation mechanisms of international law in general, states implement international law through legal procedures that are rooted in their domestic systems. How a state approaches international law depends on whether its legal system is monist or dualist. In reality, however, there is some overlap between monist and dualist principles within domestic legal systems. In monist systems, international laws are integrated directly into domestic law. And in dualist systems, international law is not automatically part of domestic law, and Parliament must incorporate treaties specifically within domestic legislation for them to have any effect. An example to this effect is Germany, which has a monist system and treats general international rules as part of federal law. However, treaties like the ICCPR, which is the International Covenant on Civil and Political Rights, are directly affect domestic outcomes, and they can override national statutes. But on the other hand, treaties such as the International Covenant on Economic, Social, and Cultural Rights require specific legislative adoption to create enforceable rights. Beyond this nature of duality, the type of law, which is whether the law is itself hard law or soft law, also influences its implementation. Hard law, such as treaties or binding United Nations Security Council resolutions, customary international law, create enforceable legal obligations, and violations of these rules constitute wrongful acts, triggering international responsibility and potential legal consequences. Soft law, on the other hand, in the nature of guidelines or declarations or standards are non-binding, but they also serve an important role in areas where flexibility or incremental progress is needed. An example to this extent are the World Health Assembly resolutions on HIV and AIDS, which have driven significant advancements in public health. In addition to this, courts play a crucial role in implementing international law, both domestically and regionally. Domestic courts are effective avenues of enforcement to interpret, apply, and harmonize international laws within domestic legal systems. These also include specialized courts and tribunals that have subject matter expertise in areas such as environment, migration, human rights, crimes, etc. Domestic courts are also useful because they enforce ICJ decisions and opinions and decisions of regional courts. At the regional level, courts such as the European Court of Human Rights, the Inter-American Court of Human Rights, the African Court of Human and People's Rights, etc., interpret and promote the uniform application of international rules and policies of regional treaties, ensuring that member states comply with such international obligations. They also incorporate localized regional experiences, developing international laws to suit diverse circumstances. At the international level, you have the ICJ, the ICC, and the UNSC, which is the United Nations Security Council, which enforce compliance. The ICJ settles disputes between states and provides advisory opinions, whereas the ICC prosecutes individuals for more serious crimes of international concern, such as genocide and war crimes, and can also issue arrest warrants and request states to surrender suspects. The United Nations Security Council, with its binding resolutions as per Chapter 7 of the UN Charter, can impose sanctions or authorize peacekeeping missions to maintain international peace and security. The UN is also comprised of treaty bodies that are entrusted with overseeing the adherence to specific international treaties. These are most generally or primarily operate in the area of human rights, and some examples include the Human Rights Committee, the Committee on Economic, Social, and Cultural Rights, the Committee on Elimination of Racial Discrimination, the Committee on Rights of the Child, etc. The function of these bodies is to review state reports, issue concluding observations, general comments, conduct inquiries, provide technical assistance, among a host of other functions. Of particular importance here is the Universal Periodic Review of the Human Rights Committee, which makes periodic assessments of states' compliance with human rights obligations set out in the UN Charter, human rights treaties, and applicable international humanitarian law. In addition to these, there are also specific subject-specific monitoring mechanisms, such as the WTO and its dispute resolution mechanism, the ITLOS, which has a mandate over the law of the sea, compliance committees under Kyoto Protocol to look at environmental matters, and so on. In addition to this, civil society organizations play a huge role in fundraising, holding countries accountable for IHL violations, in delivering humanitarian aid and assistance, providing medical assistance in conflict zones and disasters, and so on. Now, I'd like to move on to the second point, which is the specific context of conflicts and how international laws are implemented in relation to health and displacement. In conflict situations, the situation of international law becomes more complex, specifically because there's a patchwork of legal rules, as Professor Cantor highlighted. A significant player in this context is the ICRC, or the International Committee of the Red Cross. Lacking enforcement mechanisms, the Geneva Conventions rely heavily on the ICRC to operationalize IHL. The ICRC provides emergency healthcare, rehabilitation services, mental health support, monitors the health of detainees, and the ICRC also adopts resolutions which have relevance in the areas of displacement and health. For example, with respect to implementation, the ICRC adopted a resolution in 2019 for national implementation of IHL and called upon states to share voluntary reports on good practices. Currently, there's also a draft resolution to promote a universal culture of compliance among member states with IHL obligations. Courts in this regard also contribute to enforcing IHL during conflicts. For example, the ICJ in a specific case ordered Uganda to compensate for displacement caused by its actions. Similarly, in the Wall opinion, the ICJ highlighted Israel's obligations under IHL to maintain health services for affected populations. The ICC, similarly, in a case in 2012, has also considered states' obligations in relation to health and displacement in the context of conflicts. If we turn to implementation as per refugee law, these are centered around extending asylum to displaced persons fleeing armed conflicts, usually on a case-by-case basis. Courts and tribunals consider IHL violations as part of refugee status determination procedures. In addition, the UNHCR also performs a function of disseminating country information and guidance, outlining human rights and IHL violations, which are sometimes considered as part of domestic asylum cases. The UNHCR also engages in humanitarian activities in emergency situations, in the nature of supplying essential basic services, setting up refugee camps, and so on. At a national level, there is also an important aspect of military training in the form of disseminating military training manuals and codes of conduct for educating armed forces. Examples of this are the Denmark's military manual, the US Army field manuals, which provide detailed guidelines on issues for civilian medical objects, medical treatment of civilians, protections for medical personnel and humanitarian workers, among many others. And lastly, in relation to state responsibility for violations of IHL, states have also engaged in international adjudication and arbitration to secure compensation for losses and damage suffered by individuals and the state. Claims commissions, such as the ones established during the 1990-91 Gulf War, have been established to administer loss and damage, including for the destruction of the natural environment, which has a bearing on health and displacement of people. However, implementation faces significant challenges, and I'll briefly touch upon a few of them. Firstly, the inherent nature of conflict is chaos, and this resists the structured application of law in these times. Secondly, classification issues, such as whether a situation qualifies as an international or a non-international conflict, can also affect the applicability of IHL. Humanitarian workers and medical personnel face frequent attacks, undermining relief efforts. And most importantly, the occurrence of and responses to conflicts are grounded in political considerations, posing serious challenges to unbiased implementation of international law. A recent example is from last week, where the US vetoed the UNSC resolution on ceasefire for Gaza. Lastly, I would just like to end by touching upon some motivations for incentives and constraints for compliance of state and non-state actors. For states, compliance often stems from reputational concerns. Violating international law invites international scrutiny, undermining states' legitimacy and jeopardizing future cooperation. For non-state actors, compliance can secure legitimacy within a region. Secessionist groups, for example, may align with international norms to gain local and international support. However, constraints frequently undermine compliance as well. For states, some of the constraints are that military objectives often take precedence, and ambiguous principles like proportionality, for instance, provide a cover for violations. Internal political pressures can also lead to non-compliance. For non-state actors, there are additional challenges, including limited institutional capacity and resources. Informal organizational structures often prioritize immediate gains over long-term humanitarian considerations. And finally, asymmetric warfare further complicates compliance, blurring the lines between combatants and civilians and increasing the likelihood of IHL violations. To conclude, I'd like to say that while legal mechanisms exist for implementing international law, practical limitations in conflict situations reveal significant gaps. Compliance, though incentivized by reputation and retaliation, is constrained by political, logistical, and asymmetric challenges. I'd like to end there and invite Dr. Hugo Slim for his comments.
Thank you very much, Malavika, and thank you, David, too. And I'm going to pick up on what you've both been saying and try and go into a little more detail about some of the problems in IHL. And as David and Malavika have said, international humanitarian law is very big and it covers many treaties. And it's also, I think, in public space, constantly simplified by humanitarians for public communication and for humanitarian advocacy. And therefore, I'm going to talk really and talk to the point here that, in my view, I think IHL is often subtly misrepresented in public discourse. And we get a very ideal view of what it is rather than a rather real view of it is. And sometimes I think, watching some of these simplifications into quick messages about IHL, I think there's almost a danger of certain humanitarian agencies and human rights groups of actually engaging slightly in misinformation and even disinformation about what really constitutes IHL. So I'm going to explore a couple of these areas mentioned by David and Malavika already, where there's sort of ambiguity, and it's not just a problem of compliance, but actually really looking at what the law permits people to do, in fact. And so I'm going to explore areas where IHL is not as simple as it sounds in humanitarian campaigning. And this is not surprising that it's not very simple, because it's very long and detailed. And here are the Geneva Conventions and the additional protocols, and they are altogether 301 pages of very dense, hedged, legal text. So it's not surprising that simplifying it is difficult, and I think sometimes leans into misinformation about what the law actually says. So the other problem with that is actually most humanitarians, in my experience, have not read the Geneva Conventions and the additional protocols, so they are operating on the basis of the simplifications passed on to them. And I suppose what I really want to talk about is that, you know, the failure of IHL, such as it is, and in fact, a lot of IHL is respected and people are receiving aid, health, clinics, support, protection every day. So a lot of IHL is positively enabled and applied. But the failure is stereotyped as one of compliance, when in fact, I think the difficulties for humanitarians, particularly to face up to, is in fact in the law. IHL is quite permissive. You can in fact kill a lot of people and destroy a lot of property under IHL. And there is an implicit recognition in IHL that war is about winning as well, hence military necessity, military advantage, and therefore it shouldn't prevent you from winning at one level. So I'm going to look at several areas. First of all, I'm going to pick up a little bit on what David was saying about rules and principles and the difference between them. But then I'm going to look at where those rules are often qualified as well. And then those principles are open to interpretation, so become a little more elastic than humanitarians might like, perhaps. And I'm going to suggest, I'm also going to look at the problem of non-reciprocity, the fact that even if your opponent is breaking every IHL rule under the sun, you can't if you've signed these conventions. And these are deep problems in IHL, I think, not just about complying with it, and which people, I think, underplay around the crisis of IHL at the moment, if we have one. So first of all, the rules and principles. As David said, humanitarian law is a mixture of rules and principles. There are absolute rules which function as prohibitions: do not torture or rape, do not deliberately target civilians, do not commit reprisals, do not take hostages. There are also rules which function as injunctions, things you must do: facilitate provision of relief, treat prisoners humanely, give warnings and precautions and in your fighting. So these absolute rules are there in IHL. But there are also a lot of principles to be applied by commanders. As David said, this is not a human rights text. It's not saying everyone has a right to A, B, and C. It's really a law for parties at war and their commanders. And so there are principles to be applied by commanders with judgment. And the tricky one, of course, there is proportionality, as Malavika and David have said already, military necessity and military advantage, and even sometimes distinction. It's up to a commander to judge how distinct a setting is between civilians and combatants. So IHL is, in some ways, permissive of a lot of suffering. And I think that's hard for humanitarians to believe, in a way, because it's called International Humanitarian Law. So let me give you an example of where those rules actually have qualifications. So you may have an article that sets out a rule, but you'll have some little paragraphs under it, which often begin with words like unless, if, only, provided that. So if I give you two examples, the prohibition on attacking medical facilities and medical units, in AP1, Additional Protocol 1, Article 13, it makes the general rule, but then, of course, comes up with some qualifications, unless that is being used for military purposes, et cetera, et cetera. And then it defines what's legitimate military presence in a hospital. You can carry weapons, people may be arriving wounded with weapons, but if you're using it as a military base, then the absolute prohibition is qualified and fades away. And that's been a major dispute in some of the wars recently. The other one that is a relevant qualification for humanitarians is Geneva Convention 4, Article 23, about the provision of relief. And again, you get a basic rule that all warring parties should facilitate the provision of relief, but then you get some unless paragraphs, unless they think it is being diverted to other units or causes, unless they don't actually control the area it's going into. So, there is no control by any party to make sure that relief is properly applied, or unless that relief is being used for military advantage by one side or another. So again, that apparent basic rule is qualified in the text of IHL. So I'm just saying this to problematize IHL, and it's not just about compliance, it's about complying what? Because there are a lot of levels of qualification, even around the absolute rules. And that's not something you hear from humanitarian campaigners who tend to focus on the basic rule and don't mention the qualifying paragraphs. The third thing is that this happens with principles too. So if you basically have these principles like proportionality, military necessity, it's up to commanders to interpret those. And therefore, this is a law not just about rules, but about interpretation on the battlefield. And proportionality, in Additional Protocol 1, is about what is excessive collateral damage and suffering of civilians, destruction of civilian spaces and things, in proportion to the relevant military advantage you are trying to achieve, you're trying to win. So these are operational judgments. They're not law as such, in a sense. They're reliant on the interpretation of commanders against various principles which they understand. And we see that because we're talking about displacement. We see that even about displacement. So you can look at the Fourth Convention and look at Article 49, and you'll see that there's a basic thing to sort of prevent displacement. But then there is a qualifier which says, unless it's absolutely essential for security reasons or for the protection of that community, then they can be displaced by evacuation. So again, that's a judgment on that basic rule. And in proportionality terms, the sort of key word is always minimizing, but of course that's quite a relative term as well, depending on what you're trying to achieve in what kind of setting. So principles are also problematic. They're not just nice and easy. The final point I want to make about IHL, because I've just come back from Ukraine, where this is a really burning issue, is the principle of non-reciprocity that sort of sits in the first article of the convention, the Common Article 1, and then in the Additional Protocol, first Article 2, which makes very clear that a warring party, a state, has to respect the conventions and IHL in all circumstances. And that means even if your opponent is breaking every rule in the book and winning, and you look like losing your country and living under, in this case, Russianization and oppression for the next 10, 20, 30 years or whatever. And this is a really difficult issue in places like Ukraine and many other places. You hear people saying, but this is just completely morally unrealistic. It's completely morally unfair. And, last week in Ukraine, it's about if the Russians have laid 2 million landmines and we can't get past them to win, surely, at this point, we can start putting in a few special kind of landmines to attack and to defend ourselves better, to stop them invading and taking over our country. So there's a basic moral problem in the non-reciprocation principle that sits in IHL as well, which I think is creating real skepticism in some quarters about the law as well. So I just want to finish by saying that I feel sometimes that humanitarian campaigners, and I've been one a lot, often operate with an idealistic reading of IHL, and they read it almost with sort of confirmation bias, where they're only looking for the humanitarian bits and sort of don't see the qualifications or the potential interpretations in the principles, which make suffering much more permissive under IHL. And I have a feeling that this is because some humanitarian campaigners are actually war abolitionists. I think a lot of them really want to abolish any human suffering in war. And we see this endlessly happening in policies being developed beyond IHL for urban warfare, for this new notion of the full protection of civilians, not only now, but in the reverberating effects that wars will have on health systems and everything else. So there's I read it as a war abolitionist trend in the way IHL is understood, that it should offer full protection. And of course it doesn't. And anyone who hopes that IHL is going to, be in any way a sort of abolitionist text for human suffering in war will be very disappointed, as they are at the moment, because there is still a lot of scope in IHL for applying force in such a way that creates a lot of human suffering, and not all of that human suffering necessarily is illegal under IHL. And I'll stop there.
Thank you very much for all three of you. Where to start? Perhaps firstly to everyone on the participants, please feel free to ask some questions. And I know Adam Coots has asked a question there, and I'll paraphrase it and I'll actually like to ask the three of you. The Lancet Commission, what we're trying to do is to come up with some sort of recommendations, but also be realistic. And so I would say, number one, with all of the caveats to the rules and principles, I hazard to guess even now, if we opened it up and tried to revise international humanitarian law, that we would never get the consensus that we had originally with these. And so one question is, would you consider ever opening up IHL? What sort of changes would you recommend? And then secondly, would you even consider doing that in the current situation we're in? And then number two is, what are some feasible ways? The next question is, and Adam is looking at this, I mean, I think many of us would say, yes, the UN Security Council needs to be completely revised. It's dysfunctional, but we also know that's not going to be happening for obvious reasons. And therefore, what are some other ways to address or to hold groups accountable with all the provisos that Hugo has mentioned? And I think that's sort of the crux of what we're trying to address. So I think, given the rotation, if we can just go back and to ask David and then Malavika and then Hugo to address some of these issues, I'd be grateful. David, over to you.
Well, many thanks indeed, and thank you for the question, Adam. I think there's a number of points to be taken here. I mean, the first of these is to come back a little bit to what Hugo was saying and what I mentioned at the very start, which is, all of these bodies of law are not idealistic. And, if we think about law in that way, then that's only, I think, going to take us so far. But they are rather a balancing act between practical interests, particularly of the powerful actors who create laws, and some infusion of idealistic objectives as well. And I suppose, Paul, I share your concern that, opening these things up, what would be the different balance between idealism and practical considerations in any new body of human rights law or IHL or refugee law? And it's not clear to me kind of where that would sit or where that would lead. I mean, I think if one goes too far in one direction towards the ideal, then you run the risk of having something which is simply dead letter law. And, you know, one can think of laws in particular countries which reflect that. And going too far the other direction and really watering down the idealism, that really seems to be the tendency. I mean, you look at some of the comments of people who are being picked to head up the Department of Defense in the US about IHL. And really it's seen purely as a set of constraints upon action. But if you go all the way towards removing those constraints, then I think equally, you know, you go somewhere which, you know, many commanders in the field certainly would be unhappy with. You know, part of IHL's appeal traditionally has been said that if you think about others applying or breaking those rules in their application to you, you know, how would you feel about that? If you're a commander, you know, would you want your unit when they're taken prisoner to be treated according to the Geneva Conventions or not? And it's those sorts of appeals to reciprocity. But I absolutely agree with the point that Hugo's made, which is, you know, the non-reciprocity aspect of it. In other words, you know, if violations really aren't punished, you know, where does that leave one? I think leads us down the route that Malavika was talking about, and thinking very carefully about how one does improve compliance. So, you know, I think you're right. There is a question about non-reciprocity in the rules themselves, but it also is a question, it leads into questions about compliance equally. I suppose in all of this, you know, the broader question is, you know, what is the point of law in a context like war? You know, is it a set of values, you know, a point of reference? Is it something that we see as, you know, guiding the behavior of those who hold power? Is it something that we see that, you know, establishes a framework for punishment for those who breach the rules? So I think that, you know, there are a number of ways of looking at law. And, you know, I would say that even though, you know, laws are broken, that doesn't invalidate the laws. And I think Hugo's point about actually IHL is relatively permissive compared, for example, to many areas of human rights law is the right one. You know, if we look at this simply without reading the qualifications, we have a very skewed idea of what IHL is about. And, you know, ultimately that leaves us with, you know, a false impression about whether law is being observed or isn't being observed. You know, IHL is observed in many areas and, you know, in a number of conflicts, but there are aspects of it which are less observed in particular conflicts and so on. I think, you know, focusing our attention there and thinking constructively about what those particular areas are and why there isn't compliance, either in particular conflicts or in relation to particular rules, would be where we would want to think in terms of moving the debate forward.
Thank you, David. Malavika, over to you, and maybe just a slight variation of the question is also, so many of us are not legal experts, obviously, and it's I would say most humanitarians are seeing, or at least observing, egregious breaking of IHL. So is there a line? Can these always be, the provisos always be used to say, well, we're doing X, Y, and Z and that's legal? Or where is there a clear breaking point where it's you could make a strong case and then bring people to justice?
So firstly, I would like to say that I'm also myself learning about how to go about reforming the system. But I think that following up on what David said and what Hugo had highlighted before about the structural problems within how IHL is constructed, I think there is a scope for moving the debate forward by focusing on soft law, for instance. And if you look at an example would be, you know, asking non-state actors to come up with voluntary commitments for accountability, right? So if you look at Geneva Call, for instance, it has deeds of commitments where it is asking non-state actors to sign up for the prevention of starvation, for instance, right? So in these kind of things, it allows more flexibility to function within the system, but to also devise new commitments based on specific realities, I would say. And I think that this can coexist with the top-down rules that we have in IHL, because they might not always target specific crises and problems.
Okay, thank you. Hugo, over to you.
Thank you. So reflecting on your question, Paul, and thinking of Adam's question in the chat, how do we reform it? How do we think anew about it? I'm not as pessimistic as some people who say, oh, if you take the lid off it now, it'll all pour out. We'll never get anything in the tin again. I think there are other ways to be creative about this. I always remember when the cyber thing first came out, there was that rather interesting group of scholars that went off and were convened in Tallinn and produced the Tallinn manual on what, IHL might look like in relation to cyber law and cyber attacks and all that stuff. I think those are quite interesting exercises. And I think there's no reason why groups of people, and perhaps even a few states, or states might convene such sort of thinking and reviewing, might say, now, look, these are the challenges we face. We've got some very good, good parts of the law which we want to keep. And I think, as David says, most commanders, most people do want to keep basic laws which mean they can go on being human themselves and humane. But there are real trouble about areas of conduct of hostilities and asymmetry, the word that Malavika used, about when someone's breaking it and you're not. How are we going to deal with this? And I think to go away and think about that and produce new texts and either expose some of the difficulties in the law at the moment, which people are sort of covering over, could be very useful at this stage. And often that's what happens. People go off and have ideas and form little groups and brainstorm, and that can bubble up and be ready for the right time. And then if there is a political moment where the sort of clouds break and you can get through, you're sort of ready. So I think people should be thinking much more now, convening much more now, and saying, look, we have a problem. And it's no surprise now, because we're potentially going to fight what I called very big wars soon. And we are fighting some really big wars now around the world. People are. And that wasn't the case in the heyday of ICRC and the heyday of IHL in the last 30 years, when actually the really big military powers were either reserved or just fighting sort of pinpoint counterinsurgency or limited war in various places. As they gear up to fight each other potentially in various ways, then it's not surprising people are thinking differently about, is this law going to work for us? Or are we going to look pretty silly if we obey every bit of it and the other person doesn't?
Okay, thank you. I have a couple questions, but let's move to Sarah, and maybe I'm going to, because of the time, I won't ask everyone, but I'll ask David perhaps, or anyone else. I'm sorry, anyone else who would like to answer this in terms of the private sector. So how can, and or I would add, should, the private sector be involved in this discussion, and what are some of the means of holding them accountable? Anyone feel comfortable, David, Malavika, or Hugo, to address this?
I think they should be. I mean, certainly, everyone engaged with cyber warfare, autonomous weapons, has been deeply round a table with businesses and IT companies and, new tech companies. I think they have to be part of the thinking and the decision making, because in a sense, the world has changed. It's the business sector now that holds the majority of kit that can be, used in war, whereas, in the last century, it was the defense, military contracting others that held the power in the military kit. That's changed. So people have to be around the table.
David or Malavika, any thoughts on that one?
Yeah, I mean, I suppose incentivization is, what Hugo was speaking to on the accountability side in terms of, where there are violations, where rules have been broken. Then, of course, national courts are an obvious port of recourse, and there's a great deal of work being done on accountability of the private sector and how one holds companies to account in relation to breaches of rules. You have to think only, for example, of Chiquita in Colombia and their involvement with paramilitary groups there in the armed conflict in Colombia. So those sorts of routes are very much used. Malavika, I don't know if there are other points from the implementation side you wanted to address.
I mean, I'd just like to add that there has been movement in this regard. You also have the UN Guiding Principles on Business and Human Rights, which kind of lay out, the obligations of businesses in protecting human rights. So something similar for conflict could also come up.
Thank you. I see that Anne and Richard mentioned that, yes, in a way it's a misnomer to talk about IHL, and perhaps laws of war may be easier, but I certainly know that many, again, lay people look at it and say, how can you have laws of war given what war is? But I think it's important that we do have that. And then Donald was mentioning, is there a reason there are no military representatives here? When I've tried to convene military and humanitarian representatives in humanitarian discussion, it seemed to be the humanitarians who struggled with military voices. Any thoughts? Because we have 4 minutes left, I would like you maybe to discuss. I'll go to each of you just in the same order. And I'd also like, maybe you can respond to Donald's question, but I also, just as an overall summary, I think many of us humanitarians are clearly not frustrated with the situation that's happening now. And I wanted to get to this point about collateral damage. How, firstly, horrible name, but where are there limits? Could there be limits to be able to say, well, if you're taking out a target, a very important target, can there be a limit of how many people or civilians can die? Because I know that there are the military put ratios on this, but they seem to be changing all the time. So with that, over to David, then Malavika and Hugo, and I'd also just like you to say one recommendation that you would make that would be far-reaching for this commission. So David, over to you.
Many thanks. I think the thing to be aware of there is, when you're talking about incidental casualties to civilians, then you also have to think about the fact that there are rules about precautions in attack. And part of those precautions are, thinking very carefully about what that balance looks like, where possible, taking actions to avoid civilian casualties and so on. And where there's doubt, of course, then the doubt should go in the favor of the civilians. And, those rules sit there behind this question of, incidental loss to civilians. I think it's very difficult. Clearly one can come up with templates and scenarios and examples and so on. But part of the reason why the rules are framed in the way that they are is that, there are a multitude of different scenarios in which these kinds of issues are likely to arise. And therefore, giving one kind of, a set of rules of thumb or numbers can make that the task of the battlefield commander or the soldier or whoever's taking the decision, extremely difficult. And that's why there is this idea of really trying to give principles that, are practically applicable by somebody who's not a military lawyer, a soldier on the battlefield, but being very clear as to what those limits are. And Malavika mentioned, training programs for the ICRC and so on, and they're vitally important in really, and military training programs in, determining rules of engagement and thinking very carefully, or getting soldiers to think very carefully about how those rules should be applied in practice so that the war can be won, but nonetheless humanitarian objectives are observed to the extent the law requires.
And one recommendation, David, you had one?
For the commission?
Yep, because I want people to think online, and then I'm going to share a link right now where they can respond. But for the commission.
Yeah, I think my recommendation is thinking very carefully in the current world about where we're taking these discussions. There's a very big push to devalue various bodies of international law, and I think we just need to be careful in opening up discussions that we don't contribute to things that ultimately undermine the very values that perhaps we're trying to raise.
Thank you. Malavika, over to you.
I think I would just quickly like to say that whatever legal reforms we're trying to propose, I think it would also be good to highlight the motivations upon which these legal reforms stand. So if we talk about humanitarian aid or assistance, for instance, I think it would be good to be cognizant of what the underlying values are, for instance, impartiality, humanity, neutrality, these sort of things, because I think that it's here where you could really make a difference to understanding what the laws could turn out to be.
And Hugo, over to you. Oh, Hugo, you're on mute.
Sorry, yeah. On the question of proportionality, which you pose, Paul, can we put ratios to this or something? I started life as a theologian, and of course, the earliest discussion I know of that's sort of written down about proportionality in war is the discussion between God and Abraham around the destruction of Sodom, when actually Abraham bargains and bargains with God and gets him down to about 10, so that God says, okay, if there's 10 innocent people in this city, I won't destroy the whole thing. But, they start at a pretty high number. I'm not sure whether we can do it with maths in that way, because I'm not sure war really plays out like that. But it is an agonizing question always. And of course, it reflects the thing that is never really, allowed to be explicit in people talking about IHL, but, the killing of people in war recognizes that human life is not the only thing that matters, and that politically other things matter, like the survival of your sovereign state, like your right to live in the way you want to live and not be invaded by others and forced to live in another way, like all sorts of other things. And this is the problem. So when people are making decisions around war and military necessity and the importance of winning this war, they're not just thinking of human life and the value of individual human lives. They're thinking of much bigger political ethics in a way. And we all do, and most of us are. So I think that's the core problem that underlies all this. If I had a recommendation for the Commission, it would probably be actually that we should look more at human rights. I like what David said at the beginning. These human rights law and IHL have always run simultaneously together, but actually human rights always been treated as the sort of, inferior sibling in war, because many people have a vested interest in saying, no, in war, we just need this special law, this IHL stuff, which, as David pointed out, is not about human rights. It's about the duties of commanders and the duties of states. So I would like to see human rights coming more into the center of understandings of people's treatment in war, so we can talk more simply about the human right to water, to food, to freedoms of various kinds, to protections of various kinds, as well as this very complicated IHL stuff, which is quite arcane and, as we've seen, full of qualifications. So I'm a bit of a fan of pushing a human rights law into war a bit more.
Okay, thank you. I'm conscious of the time, so I'll say thank you to everyone. We will send around both the recording to everyone that has signed up. We had about 160 people sign up, but 60 or so joined us today, and we will send with the Google link, and we really would appreciate your input, so it'll help us as we move forward with the Commission. Thank you to Anna, David, Malavika, and Hugo, and for all of you for attending. Appreciate it. Have a good rest of the day, evening. Bye-bye.